Numbers 10 and 11, 𝗲𝗿 versus Aidan Kearney, 23 CR 313, 24 CR 43. Let me just update this. Mr. Kearney is present and represented by attorneys Timothy Bradel and Mark Federow. The 𝗲𝗿 is represented by Special Assistant District Attorney Robert Cosgrove. The matter is on for hearing on the defendant's motions to dismiss. If the parties could please identify themselves for the record.
Morning, Your Honor. Robert Cosgrove from the Commonwealth. And I guess it's a late morning. I should have said good afternoon.
Hello, Your Honor. Timothy Bradel on behalf of Aidan Kearney. He's here in my, to my left.
And Mark Federow for Mr. Kearney.
Hi, Mr. Federow. Good
Nice to see
afternoon.
you.
Okay, so I got the motion and I got the response. Why don't I do this? I've got some questions that I'll throw out at the beginning and maybe both sides can answer them. Why don't I start with the defense and then I'll go to Mr. Cosgrove. Mr. Kearney certainly a journalist. He's a satirist. Mr. Bradel, where's the line? How far can he go to satirize things? And when does it become a crime? I asked that to Mr. Cosgrove as well to address. How does the conspiracy counts, which are 14, 15, and 16, how do they fit into this? And how is that intimidation? Are there people that are mentioned in these indictments who are non-witnesses, specifically as to counts 5 and 15? Tell me, Mr. Bradel, where you think that the motorcade, how does that fit into this? Where does the intimidation there, Mr. Cosgrove? You can obviously speak to that, but Mr. Bradel, I'll start with you.
Thank you, Your Honor. You know, as usual, Judge, you cut right to the point. I appreciate that. You know, we have about 75 pages between counsel and I, and I'm happy to answer those questions. The first, where do you draw the line thing, Judge?
Yeah, where do you draw the line?
Sure.
So he's a journalist. He's got his blog. He's got the website. I'm sure he gets a lot of activity, and he's covering a case. So he's acting as a journalist. But how far can he go?
Sure.
You know, and I say this to Mr. Cosgrove maybe as well. How about Michael Moore or somebody like that, or somebody who's a satirist in some way, or is trying to bring attention to a certain thing? How far does the First Amendment go in their protections? Go right ahead, Mr. Bradel.
Thank you very much, Your Honor. Judge, it is actually a clear line. It's O'Brien v. Borowski. Okay, Judge, I know you're all over this. O'Brien says that all of these strictures that talk about speech and distress and everything else, it's limited to true threats and fighting words. O'Brien says that. Watts in the Supreme Court says that. This is just well-settled law. It's unquestionable. So it has to be true threats or fighting words when the issue is speech. And that's what we have here, we contend, is this is just Mr. Kearney's speech.
How about if he says, what's the effect I'm going to ruin your life? Is that enough?
No, it's not enough,
Okay.
because it's not a specific threat in terms of any criminal behavior. And that actually is specifically addressed in O'Brien, and it's Snyder v. Phelps, Judge, Snyder v. Phelps. That's the Westboro Baptist Church case where they picketed a dead soldier's funeral. I mean, the most repugnant stuff you can imagine, but it's inflicting emotional distress in public on a matter of public concern is protected. So, and O'Brien specifically talks about that the fear needs to be defined. It's fear of property damage or being a victim of a crime. It's not fear of being sued. It's not fear of being embarrassed. It's not Ms. McCabe in Stoughton District Court saying, is there any way you can get him to stop blogging about me, Judge Walsh? That's not the fear we're talking about.
How about calling in phony pizza audits at a pizza restaurant?
You know, I'm glad you brought that up too. There's no evidence whatsoever, and he didn't do that. Mr. Kearney did not tell people to do anything with respect to that, but more to the point of our motion here today, there's no evidence of that. You know, I don't want to sound sneaky when when I say, oh, there's no evidence of that. He didn't do it, A, and B, there's no evidence of it, and that's what we're here for, is to look at the evidence in the grand jury. There's no evidence whatsoever that he told anybody to inflict economic harm on the guy. Even if he did, which he didn't, how is that a crime? It might be something he could be civilly sued for, but it's not a crime. But the most important point on that, Judge, is that he didn't do it, and there's no evidence of it. That points up something that we want to address as well, Your Honor, is the idea that there's so much imputed derivative liability infecting these grand jury minutes. It's ridiculous. You know, it's as if the Commonwealth just basically forgot about the notion of joint venture and just wanted to attribute every bad thing that has happened to any one of these complainants to Mr. Kearney. I'll give you a ton of examples. Proctor says people drove by and spit on my lawn or whatever. That's got nothing to do with Mr. Kearney. They have no evidence. He said, hey, let's get into joint venture here for you to drive by and spit on his lawn. It's got nothing to do with Mr. Kearney. Another example that should throw out the entire case is McCabe. Jennifer McCabe says, I got an email that someone was going to rape me on my front lawn. That has nothing to do with Mr. Kearney. The fact that there are other people, many of whom are in this room supporting the First Amendment and supporting Mr. Kearney, that are concerned about this and that speak out, Mr. Kearney is not responsible if they cross some line. It's not his cross to bear, Your Honor. If the government wants to make a joint venture case, let them try, but they certainly haven't here. And that's the most important point, is that all of these derivative liability things, you got to throw those out the window, Your Honor. You can't use them as a basis to uphold an indictment, but also there's no evidence of it. There's no evidence that he did anything wrong. So all those derivative liability things, Judge, I hope that, you know, I know you've looked at everything. When you look at it again, it can't apply to Mr. Kearney. It's just not within the law. It's not even, you know, Zanetti, defense lawyers talk about Zanetti all the time, about how broad it's become. It doesn't even come in the galaxy of Zanetti. There's no evidence that Mr. Kearney urged anybody to call the pizza man and, you know, order things and not show up. There's no evidence about the Proctor thing. He's got nothing to do with the Jennifer McCabe emails. All these things, Judge, are the government's attempt to just throw enough mud at him so that a judge who's swamped with these things says, there's all these allegations. I know you're not going to do that, and that's why we're here in front of you, is because we have every bit of faith that you're going to look at this in the way that it needs to be looked at, and that you're going to look at it on the right side of the First Amendment, Your Honor. The derivative liability stuff's got to be out the window.
Okay.
Can you refresh my memory on your next question, Your Honor?
I think I had asked a couple of questions, one of which was, where is the line, the conspiracy, which I think you talked about.
Yes.
And then the motorcade, which you talked about as well. How about the one with people who, in counts 5 and 15, who are at least, it's the same person, but it's intimidation of a witness. Is that person a witness?
I just don't have it in front of me, Judge, in terms of 5 and 15 is the allegation. Elizabeth Proctor, yes. She's not a witness, but the breadth of the witness intimidation statute, Judge, does cover family members of a witness.
Okay.
So I'm not taking issue with that, but it just goes through every single one of these. It doesn't rise to the level of threats or fighting words, Your Honor.
Okay.
It's just, you know, and the other huge issue that the Commonwealth ignores and just wants to look the other way and go after somebody out of their own self-interest, and we'll get to that later, but is this notion that political hyperbole is somehow off the table. So I'm going to rewind a little bit, and that's the Watts case. It goes back to 1969, Your Honor, when a guy who was speaking about the draft, and he said that if they put a rifle in my hands, the first person I'm going to get in my sights is the president, LBJ, Lyndon Baines Johnson. And he was prosecuted under the federal threat statute. And the Supreme Court, you know, they laid it out very clearly. This is called political hyperbole. The context, the distance, the First Amendment aspects of it, it's political hyperbole. It's not really going to happen. It's It's something that a First Amendment protected speaker says to underline their point, to underscore the force, the rhetorical force of what they're saying. So that principle, Your Honor, is sort of the foundation for a lot of the case law that I cite in the brief, that we cite in the brief, and that, you know, it's
So
political.
words to the effect of, I'm gonna destroy someone's life, or I'm not gonna let them lead a comfortable life.
Right.
That's what your argument is, that
Exactly.
even under that case law, which is obviously a little
Controlling.
bit different, but yeah.
Controlling, Your Honor.
That's,
I think the word you're looking for.
Yeah, well, that might be your word, but I'm saying that,
You know, I mean, it's the Supreme Court, and that's
Yeah.
another issue we want to talk about, judges. You know, the Commonwealth of Massachusetts just forges ahead with this ridiculous statute, this witness intimidation statute. If that statute was passed in 1775, every single one of those legislators would have been pulled out of the State House and tarred and feathered on Boston Common. That statute is ridiculous, Your Honor. It talks about inflicting economic harm, inflicting emotional harm. I think someone's going to receive emotional harm if they hear speech that says, "You're a liar, I'm going to sue you." Under the statute, that's a felony in Massachusetts, not in the rest of the world, not in the rest of the country anyway, not under the Federal Bill of Rights and the First Amendment, but apparently in Massachusetts, in Norfolk County, it is.
Okay, let me turn to Mr. Cosgrove. I think you've answered that question.
Thank you.
Let me turn to Mr. Cosgrove. Mr. Cosgrove, maybe, so some of these counts, I mean, there's obviously a lot of counts. There's 16 of them. But going to count 8, which involved a member of the state police, where he's walking out of the courthouse here, and allegedly the defendant directs the attention of certain people towards him, and then they chant and they call him names. Does that rise to the level of intimidation of a witness?
I think that's probably the one closest to the line, Your Honor,
Okay.
candidly. But if you look at the testimony and if you view the video, you'll see that he's pursued down the street, he's shouted, he's approached by people accompanying Mr. Kearney with cards that they're waving and so forth, and I certainly think he could have legitimately feared for his safety. The fact that he's a rather robust gentleman and that there are other police officers around might mitigate that fear, but I don't think it was totally unfounded.
Okay. Well, but some of my other questions, that just, you know, as we get into these specific indictments, as to the indictments that are at the end of the 14, 15, and 16, that talk about the conspiracy with the person who evidently worked for the police department to get license plates and puts them out there. What's your theory on how that amounts to intimidation of the witness?
A conspiracy to intimidate a witness?
Yeah.
Which is a little different, as Your Honor knows, from the actual intimidation.
Yeah.
There was testimony that this person had done this sort of thing for Mr. Kearney before, that she was familiar with his online activities, and that she knew that what was likely going to happen when she turned over this license plate was that it was going to be used to dox the witness. So I think that's the essential theory. And there was also a suggestion, as I recall it, that she herself had some interaction with Mr. Kearney in the past in connection with a niece or something like that, and didn't want to get on his bad side. And I would suggest there was a reason that she didn't want to get on his bad side.
Okay. As to some of the counts that go into the motorcade, where it goes to different people's houses with a motorcade of followers, the actions of Mr. Kearney, are you suggesting that he's acting as an individual, or that he's acting in some sort of a joint venture?
Well, I think the evidence would certainly support joint venture. Essentially, there was evidence that Mr. Kearney planned this motorcade, that he broadcast what the location, the gathering point was going to be, that he showed up with a bullhorn to address the crowd, that he had his cameraman, or perhaps it was he himself with his phone to film the events for later broadcast, that these people proceeded at his direction to the various locations. Only the first location was announced in advance. So they got there by following him. That when he got there, he got out of the car, and the statements varied somewhat from location to location, but harangued the occupants of the house as to...
So let me ask you about count 2. So count 2 talks about intimidation of a witness, 25 to 30 people. Mr. Kearney with a bullhorn telling a witness to tell the truth. How is that not free speech? That's the one that involves name.
It's the one that involves what?
Ms. Name, count 2.
Well, I don't want to sound like Bill Clinton. It depends on what the meaning of is.
All right.
But
I mean,
in the context of Mr. Kearney saying, tell the truth, I think the witness would clearly understand that what he's instructing the witness is tell my version of the truth.
Okay. All right.
In other words, don't change your testimony or don't testify.
Okay. And then, how about releasing the phone numbers to the public? In your view, does that cross the line, taking the phone number of an officer or of a private citizen and putting that out on his website? Is that something that you think is protected speech? Obviously, Mr. Bradel does, but from your point of view, does that amount to intimidation of a witness?
I think there's a distinction between your ordinary, if there is such an ordinary thing, as putting somebody's phone number on a website and doing it to a witness in a criminal case with the intent to intimidate that witness. And I think this also relates to a comment that Mr. Bradel made. From the defense perspective, the court is to look at this with a very limited lens. Just look at what Mr. Kearney did. Don't look at what else happened. The fact that Mr. Kearney said, throw a rock or show up for an exhibit, or and that's a hypothetical, or show up for an event, or here's the phone number, go ahead and call. Well, he's not responsible if what results from that are a ton of annoying phone calls, obscene phone calls, etc. But I would suggest that that's the intent, clearly, that the grand jury could find in posting that, and that's the practical result of what's being posted. And the intent further is to harass and intimidate the witness.
Okay. Anything that you want to say that you haven't said already, Mr. 𝗵𝗫, in support of your position? I know I started off by asking questions, but if you have anything that you want to direct my attention to,
Sure.
or that you think is important, I'm happy to listen, and I'd offer Mr. Bradel the same opportunity. I've read everything that both of you have submitted. Well, let me start with Mr. 𝗵𝗫, and I'll go to you, Mr. Chairman.
I'd just say a couple of things. First, I heard Mr. Bradel say there was no evidence of this and there was no evidence of that. And with due respect to my brother, I think he's making a layman's mistake in his characterization of evidence. When a witness testifies that I was watching a YouTube presentation and I heard Mr. Kearney urge people to order pizzas and not pay for them, that's evidence. Now, grand jurors can believe it or disbelieve it. Defendant can contest it in court if that same evidence is offered in court, but the fact is it's evidence of what happened. So I don't think the statement that there is no evidence is accurate. I think in a broader sense, Your Honor, the difference between Mr. Bradle's position on behalf of Mr. Kearney in the Commonwealth is that when you ask, where is the line?
Yeah.
Mr. Bradle's position is essentially there's no line. The Commonwealth's position is that whatever might be the case, there's two lines of cases. There's the line that Mr. Bradle is relying on here. And he suggests that to be consistent with those cases, which talk about imminent harm and which talk about threats being made to the person's face and threats of bodily injury and so forth, that this statute must be unconstitutional and that it is to be construed consistent with these civil cases that he cites. And both of the cases that he mentioned are civil cases. The Commonwealth's position is that whatever the position towards the general public, and I alluded to that earlier, the courts have said that restrictions are possible when there are reasonable limitations as to time, place, and means. And we see that in a number of ways in cases that have been approved by the courts. Cases that have recently had an approval of Judge Cannoni's order with respect to picketing in the Karen Reed case. That wasn't held as an unconstitutional violation. We have decisions in 209A orders where judges order, and I'd cite the court to the case that I didn't mention in my brief, Commonwealth versus Butler. What happened in that case, I think it's fairly well known. Your Honor may be familiar with it. Young woman on the day of her birthday went to her door and found some flowers that were anonymously delivered. I think we'd agree that if you send somebody some flowers on her birthday, that communicates typically a message. Hopefully the message it communicates is happy birthday. Unfortunately for Mr. Butler, about 3 months earlier, the court had entered a 209A order, no contact directly or indirectly. They traced the flowers back to Mr. Butler, was prosecuted, found guilty, the conviction was upheld. That sort of thing happens on 209A orders all the time, which ostensibly you could look at on their face and say, oh, this infringes on my right of association. This infringes on my right to travel. This infringes on my right to make witty, satirical statements. Nevertheless,
But Mr. Kearney is a satirist. I mean, in essence, a lot of this is satire.
well, I don't mean to be flip, but so what?
Okay. No, I mean, that's fine.
I don't think there's a special rule for satirists if the so-called satire is made with intent to intimidate.
Witness. Okay, that makes sense. Yeah, I see your argument.
I'll stop at this point.
That's fine. I'll give Mr. Bradle, I'll give you just a minute. You've made your argument pretty well, but anything else you want to say?
There are some things, Your Honor. I just invite your attention to pages 9 and 10 of my brief, Judge, where the standard of how this speech is supposed to be judged is set forth. And just a couple of quotes. Speech on matters of public concern is at the heart of the First Amendment's protection. Speech concerning public affairs is more than self-expression. It is the essence of self-government. Speech on public issues occupies the highest rung of the hierarchy of First Amendment values and is entitled to special protection. The Commonwealth is arguing the other way around. Give us the benefit of the doubt, Judge Doolin. You know, hey, evidence can be construed in different ways. Evidence needs to be linked to a particular person committing a crime. That's what they're lacking here, Judge. And this Janelle Webb conspiracy to run a license plate business, Your Honor, the Commonwealth indicted Ms. Webb, and then for some reason, and I think I know the reason, thought better of bringing the case to court and never arraigned her, never charged her, never did anything with that indictment, which I've never seen in my time. And I think what happened there was that the government, the state police probably realized that, hey, they run these plates on the sly all the time for boyfriends, girlfriends, et cetera, et cetera. And they don't want in the system a precedent where a police affiliated person, quote unquote, runs a plate and then gets indicted for a felony. And I think that's why that never saw the light of day. So there never was any conspiracy charge lodged against Ms. Webb. It's past the year presumptive speedy trial, so that case is effectively dead, Your Honor. That's an important fact the court ought to know. And also, it's not a crime to run a plate, so there was no criminal object of the conspiracy to run a plate. They just want to change, they want to erase the word conspiracy to run a plate, and let's put something in there, even though there's no evidence of it, let's put something in there that'll fly, like conspiracy to commit witness intimidation. There's no evidence whatsoever that 13B was implicated in any running of a plate. In fact, it's quite the opposite. It couldn't be more newsworthy. The district attorney had just gone on television with a remarkable statement vouching for witnesses in his case, that they were fine, they were on the up and up, and leave them alone.
That, but in terms of, so you're under indictments 14, 15, and 16. Your argument is that there's insufficient evidence for those to actually be a crime.
There's no criminal object. And even in the grand jury, Sergeant Tully admits, and he says it's not a crime, it's an administrative violation. He says words to that effect. You'll see it. And he does refer to that, and it's not a crime. That's why they couldn't say conspiracy to run a plate, against the rules, because it's not a crime. That's why they switch it to conspiracy to intimidate a witness. It's not intimidating to prove the exact opposite of what the district attorney said publicly, that these witnesses are affiliating with the state police and do know the state police and are visiting them at their home. So it couldn't be more newsworthy, Your Honor. And that's what was behind running the plate, was not to intimidate anybody, but to shine the light of day on corruption. Okay. So that's that. And Judge, another thing about this First Amendment issue, and whether it's a jury question or a judge question, this is a judge question. You're not the first trial judge that, even in my practice, that has dealt with this. And I put this in my materials. You have Judge Walsh and Stoughton.
Yeah, there were two judges, right?
Right, and so Judge Walsh actually did two things, Your Honor. He did Mr. Schiffer, who's here in the courtroom today, and I appreciate it. My other client, Mr. Schiffer, is the guy that put rubber ducks all around Canton with political statements about the Reed case. And remarkably, the Canton Police Department did a 37-page investigation that was, if they applied that much work to the Reed case, those folks wouldn't even be here anymore either. But they did a 37-page investigation into Mr. Schiffer putting rubber ducks all around Canton. And that's the Judge Walsh opinion, and you'll see it in there. Denied on First Amendment grounds. It's not witness intimidation. Denied on, and arguably...
But there's a difference between that and saying we're going to make the life miserable, isn't there?
Well, Judge, that's O'Brien v. Borowski. That's foreclosed by O'Brien. Fear of being sued, fear of being yelled at, fear of being embarrassed doesn't cut it. If I just could have one moment?
Yeah, no, take your time.
So Judge, with respect to these rubber ducks, it's the exact same kind of thing that Mr. Kearney's accused of doing, and it's thrown out on First Amendment grounds. It's Colin did it. It's statements about the case. It's the same kind of thing, and they went after him, and that's what happens when these kinds of bad statutes get used for ulterior motives by self-interested police and prosecutors.
Thank you so much. It's been a wonderful argument on both parts.
Thank you.
Both briefs were very good as well.
Thank you.
I'll take it under advisement, and I'll have something for you soon.
Thank you.
All right. Thank you.
Your Honor.
Take a seat, please.
Oh, yeah.
What's your session?
Let me just, can I talk to the lawyers at sidebar for a minute? Maybe over here. Mr. Costco, the floor is yours.
Yes. Your Honor, I can just have a moment. This morning I was informed that there was a incident last night. Apparently the defendant and a friend were at C.F. McCarthy's, which is a bar in Canton. It's next door to D&E Pizza, which is owned by one of the witnesses in this case, and his son, who is also a witness in this case, and I should say they're witnesses in the Karen Reed case, works there, and they are both victims listed within the indictments that are before your honor. At the end of the evening, the son closed up at D&E Pizza and went home. There is a video camera, possibly more than one, but one in particular in the window of D&E Pizza. And what it recorded was that Mr. Kearney left C.F. McCarthy's next door and in the company of a friend, or shortly joined by a friend, walked up, either noticed or had previously noticed the video camera, and walked up to the window quite close, pressed his face up against the window almost, and then stepped back for a moment or two. Spent a couple of minutes just staring there, and then went into a 2-minute diatribe saying hello to the witness. What have you done? I wish he was alive today. Why did you do that, Chris? He's talking to Chris Albert, the witness. I just want to know. Then he goes on to say, and I have to paraphrase from here, Your Honor, because I didn't get it all down in the brief time that I viewed it. But I know you didn't do it. Colin did it. And then he goes on essentially to ask why he is covering up for his son, assures him that he's not trying to frighten him. He just wants to know. Just wants to know. Now, at that point, he walked and went away, leaving Mr. Albert to find that the next morning when he reviewed his video. Now, we can talk about how many legal angels dance on the head of a pin here, Your Honor. I think I could do Mr. Bradle's argument for him. It's just speech. Nothing's meant by it. It's protected. I doubt I've saved him the trouble, but I've tried. At this point, I don't think it's an issue whether technically it meets the standards of intimidating a witness. I think certainly the attempt, at least in the colloquial sense, was to harass and intimidate. And we always talk about these in isolation, Your Honor, but there is a drumbeat every week of verbal attack after verbal attack on the witnesses and the officers in this case. So at this point, I am going to ask the court to set bail on Mr. Kearney. He's been released on his personal recognizance. And I am also going to ask the court to set conditions. And those conditions will be no contact, direct or indirect, or through third parties. And I mean no contact in the broadest possible way with any of the witnesses or officers testified for the Commonwealth in the Reed case or any of the alleged victims in this case. And I am going to ask that Mr. Kearney, as a condition of his release, be prohibited from approaching anywhere within 100 yards of a victim's residence or within 100 yards of a victim's place of work.
Okay, thank you. Mr. Brady.
Thank you very much, Judge. Judge, this is not how incursions of someone's liberty are done in Superior Court or in any court that I know of in the Commonwealth of Massachusetts. I don't have a shred of paper. I don't have a shred of documentation. I don't have anything on this issue.
You want to continue? I'll give you one.
Yes,
I mean, you
certainly.
gotta look at it.
Yes,
You
absolutely.
want to come back tomorrow?
I don't think I can come back tomorrow, Your Honor, but you know, the government needs to, the government should be sent out to go get their ducks in a row, no pun intended. And
Maybe we
Then
could
if
borrow
they have-
Mr. Kearney's.
if they have an issue, then they should come back for it. But you don't say, hey, I heard this thing happened and
Why
I
don't
want
I
to.
do this? Why don't I do this? I'll give you 24 hours, Mr. Brady. You absolutely have a right to review the video and you have a right to see any reports that were written. I'll see you both back here at 2 o'clock tomorrow. Does that work, ma'am?
I was going to suggest noon.
How about noon tomorrow? Does that work for the both of you?
That's fine, Your Honor, and I don't mean to prolong this unduly, but I just want to say, I became aware of this incident that happened last night at 10 o'clock this morning.
That's fine. Okay.
So,
And that's great, but the government should do some investigation
Yeah, that's
and,
fine.
give
Hold
me a
on.
chance to say
Yeah,
something.
we'll address it tomorrow at noon. In the meantime, Mr. Kearney, just stand up, stay away from that pizza place, okay? What was the name of it?
I'm sorry, Your Honor, it's D&E Pizza.
Okay, just stay away from that, and then we'll address it tomorrow, okay? All right.
So the matter is continued to March 6th at noon. Mr. Kearney, you are ordered to stay away from D&E Pizza. Do you assent to this condition, sir?
Yes.
And you're hereby notified if you're charged with a crime during the period of your release, your bail in this matter may be revoked in accordance with Mass General Law, Chapter 276, Section 58.
Okay.
Thank you.
Thank you all.
Thank you, Your Honor.